So, hello and welcome to our panel, U.S. Data Privacy Legislations Edition. Privacy is making headlines across 2023 with more and more companies allocating resources to build up their privacy teams, with the many fines attributed to, the healthcare industry, let's say, and of course, with the ever-growing sector of artificial intelligence. Where's privacy going to go? Does this mean that the U.S. will finally introduce a general nationwide privacy law? It might be too soon to know now, so let's start with breaking down the current state of data privacy state by state and the important takeaways that anyone in the legal, ad tech, and data-driven marketing teams should know. But first, I'd like to take a moment to introduce our speakers. I'm really excited about this panel, some new faces, old faces. Gary Stegmeyer joins us from Reed Smith as a partner in Reed Smith's Tech and Data Group, where he focuses his practice on corporate governance, intellectual property, internet issues, cryptocurrency, and digital assets, especially as they relate to privacy, information security, and consumer protection. Gary also focuses on advisory services relating to business strategy for privacy by design, data protection, intellectual property, and emerging technologies and markets. That's why he's here with us today. I'd also like to introduce Justin Brookman from Consumer Reports, where he is the Director of Consumer Privacy and Technology Policy for Consumers Union, the policy and advocacy arm of Consumer Reports. And in this area, he helps the organization continue its groundbreaking work to shape the digital marketplace in a way that empowers consumers and puts their data, privacy, and security first. We also have Odia Kagan joining us as data privacy expert at Fox Rothschild. Over the past few years, Odia has assisted more than 80 companies from US-based multinationals to startups on their path to compliance, focusing especially on GDPR. She joins this panel with much experience in M&A and tech transactions, bringing her ability to break down complex concepts in easy-to-understand actionable items to provide effective ongoing counsels in their day-to-day operations. Last but not least, we have Surman Altenkaya from UserCentrics. Surman works here as a senior product manager within UserCentrics as she looks and researches different privacy frameworks and legislative developments globally, US focused as well, to implement within the user-centric consent management platform. Surman is an experienced privacy and compliance professional with a successful background in driving privacy projects for multinational tech companies and fintech, marketing, management platforms, just to name a few. So lots of different areas. And she carries years of experience in having implemented these compliance at the company level and also at the intersection of privacy and business needs, which is very important, also the focal point of our panel today. So I'm extremely pleased to have you guys all on this panel, and I'm excited to get started. So let's dive in. First, I'd like to start with a larger, more general overview of data privacy in the U.S. Justin, Odia, as we know, this has been a very excited area, which has developed so much recently, especially since the last time we were on Tech Bat Talks together. So maybe let's start with what is the current privacy climate in the U.S.? Anyone that'd like to start, go ahead.
Is it Odia, do you want to start?
I don't know. I was going to say the current climate is, so I think in this situation, none of us are climate change and global privacy law warming deniers. And I think we can all agree that the climate's heating up, right? I think that heating up, I think, is a good word, right? At least on the state side. We have CBRA, which is in effect, and we had, kind of kicking off with the Sephora enforcement. Suddenly, there's also you putting a name to a face or a name to a fine. And we have Colorado right around the corner. And I can see from clients, interest in it, that everybody's well aware of California and Colorado. For some reason, like Virginia doesn't seem to be on the radar. Virginia's here too. And then we also have a lot of, state comprehensive privacy bills. I have lost count. Maybe Justin has an accurate count, but I think we're in the 20s now, right? Of states that have filed the comprehensive laws.
Probably larger, yeah.
Yeah, we have state biometrics laws, state children's laws, state AI laws, some of which are already in effect, right? Notably, New York has an employment and an automated employment decision-making law with a couple of similar bills in New Jersey, DC, probably others. So there's a lot of work. There's a lot of stuff going on. On the federal front, which I think was in your lead up, I don't know, yesterday the European Parliament had a note that said, hey, some of the things that are wrong with the adequacy proposal from the US is that we don't have a federal privacy law. So let us whip one up for you right away, right? So that may take a while, but I think that there is a lot of, the like my kids were asking me, what's a soft boil, right? Like we're at the point where we have like the little bubbles and then the water. And now we're going to see, what's it going to take if the state laws are enough to make the little bubbles big bubbles that are going to, bubble up to the federal law or, not yet.
Okay.
Yeah,
Thank you.
I think that's well covered. That's all right. I mean, obviously, California kicked this all off, and then they've already revised their law with the CPRA. I think people find the California law to be fairly confusingly written. So I think a lot of the new state laws are kind of developed on the Washington state model, which did not actually end up passing. But now we're seeing lots of versions of that, again, like dozens in the various states. But they're not all the same, right? They're and like they all have little differences and they make it hard to comply with, but they're also like some are quite strong. I think Colorado and Connecticut, and then some of the legislative proposals in like Florida and Kentucky and Oregon. But there's a counter trend of like of some folks in industry trying to pass like kind of bare bones, like not like the Utah law, for example, is a law that will go into effect, but does not really move the ball very far. And so I think so we're playing a fair amount of like both offense and defense. As far as like trying to advance good bills, but trying to stop like the weakest possible bill from landing. But also like Odia said, like there's also tons of like sectoral laws, like a lot, especially on health privacy and location privacy after Dobbs, biometrics, and so there is it's like a cacophony of lots of stuff going on, which even when it's your full-time job is very hard to stay on top of.
The volume of regulation is accelerating so dramatically in so many different directions that the ability of companies, and companies are the ones who have to deal with this, to not only just block and tackle, see what's coming down, much less actually implement and respond systematically, is impossible. And that impossibility forces people to make choices. I mean, it's fascinating how many U.S. media sites that you visit from outside the U.S. and you're just blocked because they said, sorry, our IP tracking suggests you're from, a place where we don't want traffic because we don't want to deal with the compliance burden. And that kind of balkanization, and from my perspective, really, impacts a lot of what makes the internet era, attractive. But, again, that sort of, everybody has a front row seat, I think is important because Justin and I have spoken a lot together in the past, and our perspectives don't always, converge, but I don't think we'd have but I think we have consensus that what we have now universally isn't working regardless, of perspective. And yet how we get to something that's better, we'd have to agree on what's better in the first instance. And we're not doing a great job of that in the US, or when we agreed on a whole lot of things, our system is limiting our ability to get things done. So it's really a tough, place to be. I really appreciated Odie and Justin just saying, we just can't keep track of these anymore. And as we prepared, I was frank, I don't keep track of them. And I can tell you that many clients say, call me when it's a signed law. If it's introduced, I don't care, right? The biggest companies care about introduction, and often they're behind those laws. Justin and others can speak to that, or the advocacy groups, care in that, place. But most businesses want to know about a law that got signed. Otherwise, they're not in the influence peddling or influencing business. It's just not what they do.
Yeah, and going to that, Gary, you're in Washington, D.C. So for those of us who aren't sitting by the Hill, what's happening on the inside? A lot about companies, trying to be reactive. some being proactive. What are the challenges that you see with global companies trying to get things right and move things in that right direction? And does that go in line with privacy by design principles, using privacy enhancing technologies? What issues have you seen?
So I think there are a couple things in there going on to unpack. The first is we really saw a change with GDPR, that the biggest companies really started to see privacy and data protection impacting their ability to do global business, and really brought them to the table in a serious way that I think some people would say historically they weren't serious, right? It was a name dropping thing, but getting to the table to get legislation done wasn't there. And the kind of assumption and presumption was no private right of action and preemption were like the big ticket, policy issues. And yet we've seen many companies and a lot of folks from all perspectives really bent tremendously. But at the same time, we've seen more from the advocacy perspective, a shift. I won't say left or right, because I don't think that's a good way to demarcate privacy. I think privacy and data protection are inherently nonpartisan, but we've seen a shift in light of experience in the last decade to what would have been okay before as a floor needs to go further. And the way that that's played out in the legislative process is, I would say, CPRA would be a good example. The bills that have gotten, farther than anything else in Congress in, more than a decade, have a couple of things in common. And that is, for the most part, a whole lot of the big picture issues resolved enough where we could get close. But then what happens at the end game? Well, in the recent efforts, whether it's a senator from Washington or, former Speaker of the House, individuals and groups of individuals have a lot of leverage and influence. It was very clear that if the California delegation thought a federal bill was going to be less than California, they were not going to get on board with it. And there was compromise, and things moved around, and effectively, I think I'll speak very generally, but the way the federal proposal that got the furthest was, if your law was already on the books, we were going to try and not mess with it too much. And that's sort of a conceptual negotiating posture. And so, I think the best signal we have today, I'm not sure I'm exactly answering your question, but I think the best signal we have today are President Biden's remarks in the State of the Union. When the President of the United States says narrow and focus on kids and doesn't breathe comprehensive federal data privacy legislation, there's some real politics being presented there on what the administration thinks is doable. And I think, regardless of your perspective, it's kind of a shame, but that's where we are. But I also think it's very pragmatic. And I think what that means is we're going to continue down this path of individual states, going on and on and on until Schrems 3 gets decided, calling the whole cards into question, a house of cards into question, and we go, back to the drawing board. But, I know other people have some macro, policy perspective on this, but I feel like, the folks are slugging it out in the state houses, and that's not going to get any easier for business anytime soon.
Exactly. And maybe can we zoom into that macro and micro policy perspective and where the challenges are specifically for businesses? Because that's an area that I'd like to take the conversation today. And I think it's very important for our viewers to be able to have, a more practical approach, a practical view of how they can actually create a proper privacy strategy for their company, and also for global companies, as we've talked about earlier.
So one super quick is avoid the footfalls, right? And when I say avoid the footfalls, the gotchas of screwing up on things on your website that can be seen, whether it's researchers or professional plaintiffs can just go and look and go, aha, you don't have a widget that's the right size that it needs to be. So avoiding those foot faults is one of the most common things that outside counsel just say to clients. And I have a metaphor I use, which is, look, we know zebras are going to cross the Nile. They do. And we know there are crocodiles in the Nile. So don't be the first zebra. Don't be the last zebra. And don't be small. And ideally be right in the middle. And those foot faults, whether it's not having a consent management platform that's deployed, or not having some very specific prescriptive disclosure, or the kind of easy low-hanging fruit that triggers class action lawsuits and government investigations. And often the regulators, they don't have to look for those companies that are in the middle. They can look for these sort of rogue exemplars. Maybe they weren't paying attention. And in the plaintiff's bar side, there's a straightforward formula, which is, let me find a statute, apply it to new technology in a class action way. And ideally, that statute is going to have statutory damages and attorney's fees. And that formula says, okay, I'm giving you 5 billion reasons why you needed to have a document retention policy under Illinois' biometric law, as an example. So I think, the last piece I would just say is, and going back to the zebras in the Nile, is you need to be resilient and agile. And the way that you do that, there's some good rules of thumb, right? Which is, put your users first. A lot of the companies that get in the worst trouble are the ones that appear to not put their users first. A second thing is, goes back to 2004, my boss to the Motley Fool. We did the first privacy CLE I did. He said, rule number 7 on his things was, don't be creepy. Like, if you're doing something as a business and you told your grandmother that you were doing this and she would be ashamed of you, it may not matter that it's legal. It's maybe something you shouldn't do. And that's, sort of a simple rule of thumb. And the way I speak about this to your sort of framework is, Pat Riley, the basketball coach, famously said, quoting Jerry Garcia, the musician, he said, happiness is a way, not a goal. And I think privacy and data protection are ways, not goals. And so if you're using those sort of frameworks, you'll ultimately get to a place where you're resilient and the law won't matter, because you're not doing creepy things or you're putting your users first. Those are the kind of things that are going to make any law easier to comply with, and also make it much easier for your influencers, your lobbyists, to say, let's avoid these prescriptive gotcha, rules and statutes. So that's, sort of a perspective, but I'm sure other people have much broader perspective and their own thoughts on your question.
Thanks so much, Gary. I mean, talking about how not to be creepy, how can viewers best comply with the opt-out or sale or share requirement, which is something that people come to us and ask about a lot? Sermon, maybe you can take that one on.
Yes, thank you. About the right to opt out, obviously in California, they were the first example to talk about the right to opt out of selling of personal data, and then with the CPRA become the right to opt out of selling and sharing personal data. And now with the other regulation, it's more about the right to opt out of data processing, which might cover targeted advertisement, the right to opt out of sharing data with third parties, and so on and so forth, with some variable from one state to the other. Obviously, as a global company or as a company who is acting in the entire US, the important point is to be able to adhere to a coherent and kind of baseline privacy program where you can cover kind of process to cover all of this right to opt-outs. So I think there are a few ways to cover that. First, obviously, it's about transparency and the right to be informed, and how you can give notice to your user can be via privacy policy, via cookie policy, via this individual's rights landing page, this do not sell or share or do not process personal data landing page, which can be a individual's rights tool where the user can activate their right and ask to basically opt out to whatever, selling, sharing, processing, targeted advertisement. So that's one thing that you can cover via this individual's rights tool, data subjects right tool. The other way to cover, which is especially about targeted advertisement, it's having a CMP, which might cover like how you're tracking people, yes or no, and give the notice and the right to opt out. Obviously, it's giving the right to opt out to targeted advertisement, but yeah, you have some possibilities to name your toggles, your button, to be compliant with one legislation or another one. And obviously, there are all of these preference centers too, where again, you can set your preference to be able to opt out. And anything that the company, the website owner is receiving, it's all of these tools are helping one side, the user, to express, to be informed first about what are their rights, and the other side is to be able to use all of these different tools to activate their rights to opt out. So yeah, that's a bit an overview of these different tools.
And I want to just like, piggyback off of that. And if we're you promised, which I like, the practical takeaways for companies. So I think one practical takeaway for companies is you really gotta like button up this do not sell, do not share thing. Like really, because one, it's been at the top of the California Attorney General's enforcement list since year one. It's been in the first enforcement report. It's been in the second enforcement report. It is the subject of the Sephora enforcement. California Attorney General just issued a report, was like two weeks ago, I think. It was like a Friday night, that highlighted going after specific sectors, right? Mobile apps of specific sectors, but that should not deter the rest of the sectors from doing it anyway. And again, focusing on the do not sell share in mobile apps, as well as automated requests and handling automated requests. I think specifically calling out the Consumer Reports mechanism, right? Permission slip specifically for the compliance. So I think that's like, it's like, like a really big hint when we've heard it like 7.5 different times now, that this is an area of enforcement. Now, I think important to note a couple of things here. Number one, like fix the cookie thing, seriously, like really, because it's really obvious and easy to test. And we've seen it in Europe, right? There are tools that go in and see if you are blocking the sharing or not, and really easy to track, right? So that's number one. Number two, mind your sensitive information, right? Like Colorado is rolling in, and the FTC enforcement in the UDAP section and the state list and the state UDAP litigation is leaking into trackers and pixels. So that's really, especially on the health ones and sensitive health ones, right? And Colorado's coming in, and maybe you need an opt-in for your cookie now because it's collecting sensitive information. So that's really important. And then also, substantively, this issue of sharing the information with third parties for the third party's own purposes, which we know in the ad tech space kind of, proliferates into a lot of uses in a lot of companies, but even in the offline sharing, like that is, we already know now from all the litigation and the enforcement that everybody and their neighbor now understands that there is a mismatch between the expectation of the consumer and this type of sharing. So first step in bridging the mismatch here is, and this everybody agrees on, and Jerry said that earlier, is your transparency. Like there's literally no way for anybody to know that your information is being sold through trackers unless you actually say it, but you actually need to say it in a way that, normal human beings understand it. And then the second thing is you need to have a choice in there. And there is where it gets complicated and you need, help from counsel. But first of all, you need to tell people, right? Because there's no reasonable expectation without telling them. And then the second one's a choice. California already told you what you need to do. Colorado already told you what you need to do. UDAP kind of told you what you need to do. Not really, because all of the cases that I'm aware of are, okay, this is unfair and deceptive because literally you didn't tell me. And then the next thing is, what is this consent supposed to look like? Is it like implied? Is it not implied? Is it pop up enough? Do you need an actual opt out? Do you need an actual opt in? That is kind of, right now, frankly, a first world problem because we haven't gotten there. But you really need to handle this in a way that, and like Jerry said, right, in that situation, maybe you're going to be the middle zebra that gets grazed, right? Because you did have a good disclosure and you did have consent, and your choice kind of falls a little bit short of what somebody would have wanted to have. But that is a much better position than, hey, we had nothing at all. So that's what I could say.
If I could just jump one thing into that, I think when we say everybody agrees, I'm not sure that they do, but I think a real issue that California's definition of selling put on the table in ad tech in particular is what many of us call secondary use of information. And most businesses kind of have a default perspective in non-disclosure agreements, say, hey, if you're my vendor supplier, you can use the information that I provide to you in kind of two permutations. One is only and solely to provide your services to me. And if that services definition has a capital S and you're in this business, you need to go look and see what that S means, because in many instances in ad tech in particular, secondary usage of data has been pervasive, often when it wasn't PII, right? The number of times we hear, it's not PII, it's not PII, it's not PII. And people have been doing this a long time ago. Okay, for 10 years, it hasn't mattered that it's not PII because you can link, you can reverse engineer, you can do other things. So one of the biggest challenges that companies have is companies that take a posture and say, okay, our default position is no secondary usage of anything, not just data for ad tech, of anything. What happens is they hit this log jam on the supply chain side. We're getting to a straight answer about what, if any, secondary usage exists is really, really difficult. And it's one of the greatest problems that brands have who are trying to address what Odia was talking about on the front end. So rather than transparency and choice in their supply chain, they're saying, okay, we're going to work with companies who are going to use the information that we share with them for our benefit because we have direct relationships with these consumers. Well, secondary usage, gets redefined as a sale and has all these adverse downstream consequences. But one of the most difficult things is inability to get the supply chain to just agree to that, conceptually. It has academics and advocates and other people saying, well, this is why we need fiduciary duties. We need higher standards of care. Every website needs to have the equivalent of a taxi or a hospital or a hotel's duty of care to consumers. And those arguments are resonating in part because of how the supply chain has worked. And in ad tech in particular, the sector has wrought this on itself. But if we don't find a way to get to address the sort of, secondary usage, data collectives, some of those kinds of things in ways that are less obsequious, really hard, ugly American word, or maybe not even American, but if we don't tackle that problem, we're going to keep seeing all of this regulatory stuff. But I can say, someone just said to me 2 days ago, they said, ad tech is ground business to a halt. And I said, what? And, whether it's, I think Meta losing $10 billion, the ad tech business today is not the business that it was a year ago. And it's evolving and it's responding and it's changing, but more than a few companies, really have been ground to a halt. And some people would say, hey, that's a victory. That's what we were going for. That's what we're trying to accomplish. There's a whole lot of free, cool stuff that we enjoy every day. And, I realize it's a little bit of a field, but I liked very much what Odia had to say. I think in the we're really hitting it, but at the big picture, if you're focused purely on your disclosures and trying to get it right on every single law, you're going to fail and you're going to hit those footfalls. And so finding those parameters, sort of the 10 commandments approach is where you're going to have to be at some level, because you just can't make every one of these decisions and get all of them right operationally. The former chief privacy officer, a really big company in Boston, pulled his whole team together and he said, guys, I figured it out. I know how we can comply with all these privacy laws. First thing we're going to do is we're going to fire all the employees. Second thing, we're going to shut down the business. Well, he was being tongue in cheek, right? But the point was, we have to do something that's not those two things. So how do we do that? And I think Sermon was led talking about how to get there. Odia and even Justin, I think, has some probably great big picture thoughts for how business can deal with these challenges constructively.
Yeah, I mean, it kind of goes back to your point about you don't be creepy, but it's all creepy, right? All the ad tech, and thinking it's like what you're saying, that there is a massive disconnect between what consumers expect and what actually is going on. 9/10 of websites will share data about what you're doing there with Google and Facebook and lots of other ad tech companies, and they don't care about all these contractor agreements. They don't know anything about them. They're concerned about it. And this is been the original spin of the internet, and that all the news stories are about this one thing that we keep not ever solving. And I think you're also right that I'm probably frustrating for companies that advocates have gotten more demandy over time, right? And I've gotten more demandy over time. That's absolutely right. But the things we've tried haven't worked in addressing that fundamental problem, right? First, self-regulation, that didn't do it. Given an opt-out, well, that's tedious. I'm not going to scroll to the bottom of every website and opt out or try to use these broken industry tools. What about opt-in? Sorry, but opt-in, if it's just annoying GDPR consent screen, that's really hard to use, right? So what you're seeing now, now you're seeing calls for just ban, just shut it down, right? And that's what the federal bill AdPAPA, which passed Energy and Commerce, largely did. Just stop annoying people, just end it. And again, we're seeing other options global opt-outs, global privacy control, thanks for mentioning authorizations, and innovative. Maybe there's a way to make consent more usable, more actual, more real. You're very interested in that, but it's just all about the fundamental failure to solve that one problem. We still haven't gotten there yet.
And I think, just to react, one thing that Justin said that I think is really important. I don't think that he's wrong. Need you to note that, just I don't think that you're wrong. But I do think there's a really important principle here, which is we have to calibrate these laws for one size fits many or one size fits most. And Justin is not many or most, and the advocacy community is not many or most. The best are canaries in the coal mine. But many people have a much different level of risk tolerance, acceptance. The studies are out there. We talk about actual versus express preference, where people will roll out statistics and say 84% of consumers really value their privacy. But 94% of them will be delighted to give their calendar to everybody so that they get birthday reminders for their friends.
But also the New York Times, the published I can't remember who did the research. Was it Pew? I don't remember. But they basically said all of that is because people have no idea what is going on because they don't understand, and that's the problem.
And that's the lamb's marketplace, right? People are too stupid to make their own decisions. So, right, that's the
I don't think they're too stupid. I think I am on the, there's this dichotomy, right? And I've had the cookie tracking equals arsenic in the coffee shop discussion with my European friends, right? And I don't think that's really I really don't think that's true. And I do think that in the US we have, and the laws kind of seem to reflect it, I think we have a much more strong view of our own agency in making decisions. But I think that there are variables to this, right? So all things being equal, I think that here in the US, people are more inclined to say, I want to have the choice. But I think that we haven't gotten to, in a lot of situations, in the absence of good transparency, and frankly, in situations where you are smack dab in the realm of antitrust, and you are dealing with, people with significant, with like no other choice, like go do something else. Well, there is no other thing that I can do. Those are variables where, first of all, we need to deal with that. Once we take out, we have complete full transparency, and we have a regular, like a perfect market. In that situation, okay, let's talk about the agency versus the minimization, right? But I think that I agree with you, Jerry, that it's like transparency is super hard. And I really don't know in an RTB world, how do you do transparency perfectly? But I do think that and you maybe, and the ad tech companies obviously have a difficult position here, but like you, the normal, digital property owner, right? Like, what do you do now? Can you get the A paper on transparency? Probably not. Can you have other solutions right now in a world where everybody's doing, advertising? No, because you got to do business, right? You can't go out of business, but you can upgrade it to a place where at least people know what's going on. And yeah, it's still not perfect, but again, right? We're saying we can't get to the perfect Justin wants to get to the perfect. We're not at the perfect, right? But at least we can, get to a point where it's like, what the hell just happened? I had no idea. Or like, at least
I think if you could extrapolate and explain for a lot of our tech folks on your arsenic example, because I think it's important, because in your arsenic example for Europe, when we think about privacy and data protection as fundamental rights, it's a very different perspective, because it sort of makes a whole lot of assumptions that ties into your Pew study. I think you've explained what you meant there as in comparison to your agents in the U.S. perspective. That would be important. The way I think about this is, we don't design seating on airplanes for people who are 8 feet tall, and when it comes to privacy, Justin is 8 feet tall, and he wants to protect everyone with the same kind of seating on the plane that he thinks that everyone is entitled to at 8 feet. And that just isn't how we do things. Now, should we do it for people who are 6 feet or 5'10"? We don't have enough consensus. And the first thing they taught me in law school is we can lie with statistics.
Can I take your airplane thing? I think what I'm saying is, like, yes, we don't design it for 8 feet, but like when you sit in the exit row, you get that. Do you understand what your responsibilities are? Are you able to assume them? I think we need to add that in, right? Because otherwise, maybe you don't know what you're doing in the exit aisle and suddenly something happens, right?
And how do we find that happy medium then, Justin, Gary?
I mean, I'll say first, like, I don't think I am 8 feet tall. I think I'm actually fairly representative of most people. Again, if you go to a website, should Google know what you're doing on that website? They're like 9 out of 10 people. Well, no, what the hell? No, I'm on New York Times. I'm on ESPN. Like, I don't think like 40 companies should be following what I do. I feel like that's probably representative of the vast majority of people. Going to the consent point, I mean, I think in practice, yes, I think Americans more like, market choices, freedom to choose. I also think people don't want to make like 8 zillion privacy choices a day. Even me, like I enjoy managing cookie settings out of spite. Maybe that's the 8 feet tall part of me, but like most people just like want it to not happen, right? And so I think you're looking at options again, like maybe we just prohibit certain things. The alternative is like maybe people should make like one choice. Like if you don't want your data shared, you probably don't want anyone to share it. You don't want ESPN or Disney or the same company, New York Times or Fox or whoever. And so that's why we've like worked on again, I want a more aggressive model, but maybe global privacy control. You can tell everyone just right. And again, that was the basis of the Sephora settlement. California is going to that model. Again, these are all opt-out based models that we're actually seeing in the United States. And in order to make them work, they have to be fairly universal. Colorado and Connecticut have also adopted that model. So again, I'm trying to be flexible. Again, I think this is not the optimal policy solution, but in an opt-out world, you need to be able to make global choices. And again, maybe that gets us there. Maybe that's where we can meet in the middle. That's my hope.
The right thing,
Yes.
Sorry. I want to bridge the I don't know, the aisle, right? We're on the plane between Jerry and Justin. So there was a really interesting report that came out of the European Commission a few days ago with respect to the UDAP, the European equivalent for UDAP, right? The Consumer Protection, Unfair Consumer Protection Directive, right? Or and it's basically the same standard, right? Unfair or deceptive. And basically they said this was specifically with respect to data generated, processed by cars, right? For connected cars. And basically they did this really detailed report on what constitutes reasonable expectation of the individuals. And it was interesting in the sense that it basically said that both Jerry and Justin are right, and we need some solution that bridges that. Basically, it said, yes.
We know that we are, by the way, Odia.
Yeah.
We know that we both
You know,
are.
so people really care about who they share their information with, but they don't care to the granularity of who they share their information with, right? So they care about what type of information is shared and what is the purpose, but they don't need to know that like granular names of like.
So I think that I think that people actually care far less. They care more about creepy things and things that are inconsistent with their expectations in the context. So in Justin's example, I think most people are like me. His example is most people have no idea how the internet actually works, how pages are delivered, how the vendor supply chain works. And candidly, the industry has done a bad job of that. If we're going to fundamentally shift it, which is the less than ideal policy alternative, he's suggested and advocated for a long time, that probably isn't something to do within a year. And a whole lot of things that people like will absolutely go away. Now, will everything go away? I like this calendar example, right? Because there's a lot of companies that do a lot of things I don't really care for, but I frankly miss ads that were more relevant for me. And I'm a automatically reject all person. I don't use one of the like ad blocker browser extensions, but I've started to not automatically reject all. And I find, figuring out what the choices are, having done this for 20 years, if I can't figure out what's going to happen through my choices, and this is what I do for a living, we're not in a great place. And I think that's where the frustration comes from on the consumer side, and where, frankly, I think Justin is in the vanguard of pointing out, right, there has to be, sort of a better way. And things have gotten better, but a byproduct of getting better is the number of choke points that we have on the internet that are basically controlling all innovation and user experience are proliferating. They're proliferating because the largest companies are in a better position to spread the costs of these compliance obligations. I think I saw some statistic that said for GDPR compliance, Microsoft had 1,600 engineers working, full time for a year on it. That's a lot of people.
But that wasn't just about to be precise, though, that wasn't just a cookie compliance situation, right? That was all of their.
But the point is, they had 1,600 engineers just working on that, right? So the company that is going to change the world, whoever that may be, that has 30 people, we end up going more in direction. We won't see or have some of the innovation because we've changed fundamentally how the internet's going to work. But we're not really having that kind of policy conversation at the consumer level. It happens in the back halls of these, state legislatures and trade groups, interfacing. But I think consumers ultimately don't have any understanding of the underpinnings of the internet and all the things that are available to them by virtue of how it's worked for a long time. And we're coming to grips with that, right now. And in the meantime, for webinar purposes, I'm a company out there with $40 million in revenue, and I'm just trying to do what the law requires, and I'm caught in the crossfire.
Thank you so much. And I think that makes absolute sense when we're looking at the consumer, and user trust has a large part to play with that. Transparency has a large part to play, and maybe the marriage between technologies and privacy, and just, that's where privacy by design to plan out something that I speak with a lot of people in Brussels about as well, just kind of anticipating where legislation is going and really being able to have a user-friendly experience when it comes to consent, and that also might be a possibility. Thank you so much, guys. Before we wrap up, I want to bring out the crystal ball, and a lot of our users are always asking, okay, are we going to see nationwide privacy legislations? Are we only going to be seeing like statewide things? And so I want to open up the discussion and ask, where do we think that this is going? Do we think that we're going to see a nationwide legislative approach to privacy anytime soon?
I'll jump in. I'd say like my short term no. Again, like there was, but then again, the bill that was considered last year got a lot farther than I thought it would be. It was far stronger than I thought it was going to be, and it got farther with like broad bipartisan support. Again, kind of like, which is the way the winds are going. Whether the winds are going that way is a good or bad thing, we may disagree. But I also think now with a split Congress heading into the last 2 terms of like, it's going to be very, very hard to get it done in this term. So I think for the next 2 years, it's likely to continue to be at the state level. And then we're going to see, again, the states are iterating too. They're seeing, what works and what not. CCPA, like they said, like, don't sell your data. And then every company said, we're not selling your data, we're giving it away. So it doesn't apply to us. And they're revising the law to address that. And so they're iterating. They're revising regulations. And again, like I think to their part, like they are cognizant that other states are different. And I think they're in communication and trying to make them consistent. Like they again, like in the Colorado law explicitly says, try to be cool with the other states. And they're very aware of that. And they are, I think, sympathetic to the compliance obligations. But that said, like, each state legislature is bespoke. They're going to do their own thing for better or worse, because the market hasn't met, because we haven't solved these fundamental problems. So it's going to be, I think, hairy for a little while and I think it's a little ways before we get federal law.
The next time we jump on a Tech That Talks, a little more. All right. Well, thank you so much, Justin, Odia, Sermon, and Gary, for your insights today. And I hope that this is very beneficial to our viewers. And I hope to see you guys soon on another Tech That Talks, talking more about everything that is to come in data privacy and how state legislation is evolving. Thank you so much, guys.
Thanks so much for having us.
Thank you.
Thank you.